Right, let's go live to the High Court in Pretoria now, where we'll find my colleague Slindelo Masikane. She's been following this trial since the beginning. Slee, let's just stop before we talk about the fact that the state has said that this other docket has no merit. I want to understand exactly what was Advocate Defo arguing when he basically got into, and I'm very careful using this word, into a fight with the judge.
Maybe a disagreement of opinions in terms of how court processes should be unfolding, but I think it's to be expected in terms of what we're seeing unfolding in this trial. We are actually really seeing both defense advocates really standing up for the rights of their clients. We've already heard from Advocate Mshololo saying that the fact that there was non-disclosure in terms of the second docket was unconstitutional for her client in terms of preparing a defense. And what we've really been hearing are submissions from Advocate Mshololo around the fact that she now needs to thoroughly consult, thoroughly examine what's been presented to her. And before we adjourned, we were on the issue around dates and as to when we're going to postpone this trial and see it resume. That tiff between Advocate Defo as well as the judge is around the fact that the judge feels as though Defo is not observing court protocols when it comes to how the trial should be unfolding. He says that at this point, Advocate Mshololo's chance to be able to lay her grievances to the court, and Defo will be given time to subsequently respond when that time arises. According to the judge, he believes that Advocate Defo is interrupting Advocate Mshololo in terms of her making her submissions as well as her case around a possible application for a postponement. So I think that's where the disagreement was. However, Judge Mamela also feels as though Advocate Defo is undermining his authority in this court.
I heard him actually say that at some point he was actually quite annoyed because Defo wouldn't answer the question around the dates. But Slee, let's go back to the state writing to the court saying that Docket 375 has no merit. Explain this further to us and whether or not the state actually explained why they would actually hand in this document then, or this docket.
Yeah, I think that's why we're going to see quite a bit of a lengthy postponement, because in terms of Advocate Mshololo's questions around Docket 375, that letter essentially didn't really address some of the concerns that were raised by Advocate Mshololo last week in terms of why there was a decision not taken, or why this unsigned document, as it's being referred to, actually an unsigned memorandum according to the state, why it was never, one, signed, two, what really informed the decision not to pursue it. We know the letter says that the document itself is around the opinions of a junior advocate. So the question then becomes, who is that junior advocate? So I think the letter at this point has raised even more questions than we have answers. And you'd remember there are actually two letters, two copies of the same letter. One letter was handed just as court proceedings began. In the middle of Advocate Mshololo reading this first letter into the record, another letter then became available, and the state said that they had just received it and that was the latest version of that letter. So I think some of the concerns that Advocate Defo wants to raise are around the fact that we have two versions of one letter.
And Slee, you know, in terms of these two letters being handed in, etc., the state, their explanation about knowing of the existence of the docket in January, and Advocate Mshololo saying that she only received it last week. At some point, she even called the state. She said the state is lying. She used those exact words. What happened between January and last week with this docket and the exchanging of it in different hands?
So according to the state, they had requested a copy of the docket back in March from the investigating officers of Docket 375, but were refused access, essentially, and Advocate Tifo was the only one given a copy of this docket. But that's when Advocate Mshololo then also raised her objections to say just because she may have known about Docket 375, it doesn't mean it was disclosed. She never got a copy of it, which is where the dispute is now coming in, where she's accusing the state of forcing them or putting them in a position where they had to plead not having all the facts actually disclosed to them in terms of these two dockets. In fact, she was alluding to the fact that these are grounds for a possible mistrial because her client was not given an opportunity to properly craft a defense in terms of these two documents, and was actually pleaded to these charges, whereas there's a possibility that other people were meant to be charged as well.
And she said that she wants to still make an application with regards to what they now call Exhibit C1 and C2, these two letters from the Director of Public Prosecutions. But has she made any indication that she will, in fact, cross-examine, from both dockets? Is she going to use even the evidence in Docket 375?
It seems there's definitely a possibility. She, of course, has no issues with the two letters being handed up as exhibits for the court. And now that she says that there's some kind of clarity or acknowledgement from the NPA around the existence of Docket 375, she'll now be able to continue with cross-examination. But, of course, she still needs time to properly peruse Docket 375, as well as consult with her client and her possible witnesses as well.
All right, Slindelo Masikane with that report from the High Court in Pretoria. Let's leave it there for now. As you know, the judge and those advocates, all parties of the advocates are actually hoping that by 2 o'clock there'll be an agreement on a date to which the trial will continue.